So I have an important update in the Suppressor Freedom lawsuit, which aims to remove a statewide ban on the purchase and possession of suppressors. So let's talk about what is now happening. Now, really quick, before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you enjoy this two-way content, if you want to help this channel to grow, please consider subscribing to the channel. And thank you to everybody who is already subscribed. One of the goals right now is to reach 700,000 subscribers, and we're really close. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we are going to be discussing two lawsuits which aim to remove a statewide ban on the purchase and possession of suppressors. The cases we're going to be talking about in this video are Morse versus Raoul, and then also Anderson versus Raoul. These two lawsuits are filed in a district court in Illinois, and they seek to remove the state ban on the purchase and possession of suppressors. These lawsuits are important because although 42 states actually allow for the ownership and purchase and possession of suppressors, there are 9 jurisdictions within the US that do not allow that type of acquisition. These lawsuits could actually be the first in the nation which find that a statewide outright ban on NFA items like suppressors is in fact invalid. This lawsuit could also have major implications for statewide bans on other NFA items like state bans on SBRs like California also has in place. Currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment at all. Therefore, they're requesting that the judge in this case grant a judgment on the pleadings in their favor and throw this entire case out. Because of this, in the current motions, the court has stayed all other proceedings in the case and is moving towards actually deciding the case on a judgment on the pleadings. The plaintiffs in this case are attempting to avoid having this case thrown out by adding additional Pro 2A cases like the Miller and Duncan cases out of California to show that these items like suppressors are in fact arms protected by the Second Amendment. However, the looming Supreme Court decision in other Illinois cases like the rifle magazine ban cases and all of those cases which are currently seeking immediate Supreme Court intervention, all of those cases are also impacting this case here, which is dealing with suppressors. This lawsuit is important because it uses the Supreme Court's recent ruling in Bruin to attack a state ban on the purchase and possession and ownership of suppressors. In Bruin, the Supreme Court issued an opinion authored by Justice Thomas, which struck down New York's May issue CCW licensing scheme, and they found that it was inconsistent with this nation's history and tradition. One of the primary findings of that Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. This lawsuit here aims to finally make a state actually explain why their outright ban on NFA items like suppressors is in fact consistent with Heller and Bruin. In the Anderson lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. Now, this is important because it is well established now that modern arms are in fact protected under the Second Amendment, not just muskets like you hear a lot of people on the anti-gun side like to argue all the time. In fact, the Supreme Court reiterated that fact in Bruin. The Supreme Court stated that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to the historical understanding, that general definition covers modern instruments that facilitate armed self-defense. So the argument that suppressors are not protected since they did not exist during the founding is irrelevant, and the arguments that this new technology is not an arm or these accessories are not arms also is irrelevant. But now the state of Illinois has also filed for a motion for a judgment on the pleadings. The entire motion is based on the state's argument that the cases here should be thrown out because suppressors are not arms protected by the text of the Second Amendment. For those not aware, a motion for a judgment on the pleadings is a motion made under the Federal Rules of Civil Procedure, and that's a 12C motion. It is used to attack the sufficiency of an opponent's pleadings and essentially the viability of their underlying claims prior to a trial actually taking place. The court, in reviewing that motion, is strictly limited to only the contents of that party's pleadings, and then also any documents that are attached to the pleadings. So the state of Illinois is trying to get this suppressor lawsuit thrown out and then also prevent any future challenges on this specific issue in Illinois. Now, in their motion, Illinois argues that plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons, according to the state of Illinois. They are not used for self-defense. They are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus the plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearms ownership that firearms cannot be used effectively without them. They go on to state that silencers do not satisfy this definition of arms. A silencer is a firearms accessory. It's not a weapon in itself, nor is it an armor of defense. So the state's primary argument is that suppressors cannot be considered an arm under the text of the Second Amendment, and they're also not an arm because they're not an actual firearm. It doesn't shoot a projectile. They believe a suppressor is simply an accessory, and as an accessory, it's not protected. Now, two things on this point. First, the state wants to discard all other laws, including the NFA, and their own application of the NFA, which actually defines and treats suppressors as actual firearms. They're considered actually as firearms under the federal laws, and a lot of states and the federal government treat them as weapons in their own right. Second, they want to gloss over the fact that the Second Amendment does not protect just, items that shoot a projectile. It says arms, and it's anything that's an armor or defense or anything that someone can cast or use, for protection. But it also, again, protects all those critical components and accessories. They tried to say, well, as an accessory, it falls outside the Second Amendment, but nothing in the text of the Second Amendment also says that an accessory should not be considered an arm. Now, recently in this case, two other critical decisions out of California have been used as support for why the state of Illinois' ban on suppressors must be struck down and why this whole accessory argument is not valid. Many of you are familiar with the Miller California assault weapon ban case, and then also the Duncan magazine ban case, which were recently decided by Judge Benitez. And in both of those cases, he ruled in favor of the Second Amendment, striking down these bans on rifles and magazines. The plaintiffs in the Illinois suppressor case submitted those two cases to the judge as support for why the court should deny the state of Illinois' motion for a judgment on the pleadings. And they should reject the argument that simply as accessories, these items can be banned, or these suppressors can be regulated the way that the state of Illinois wants. Now, recently in this Illinois case, the judge decided to halt all other activity until the judgment on the pleadings is ruled on. Now, one of the concerning things that I will say with this case is how intertwined it is with the Seventh Circuit's recent rulings and decisions in PICA and some of those cases that are currently proceeding forward. Many of you are aware that recently in the PICA cases, the Seventh Circuit said that if an item is useful for military service, well, then it's not protected by the Second Amendment and a state can regulate them however they want. This, of course, is not correct. It's not the correct type of analysis under Heller or Bruin, but that's what the Seventh Circuit recently said. That's what they're pushing for. And right now, all those Illinois rifle ban cases are being pushed for Supreme Court review. And we're waiting to see what the Supreme Court is going to do with all those PICA cases. Also, right now, a lot of those cases are proceeding forward at the lower court level. They're heading towards a merits decision by the lower court judge there, Judge McGlynn. He's trying to push them forward as fast as possible. But here with the suppressor case, it's so intertwined with those. Recently, we also saw in this Illinois case when it was kind of originally filed, the judge there said that he was going to kind of try to take some of the guidance for what was going on with PICA and the rifle ban cases and how some of those arguments could, interplay with what's going on here in Illinois. Because again, keep in mind with the PICA lawsuits, they're also a challenge to the magazine bans. And one of the state of Illinois also was arguing in those cases that as accessories, the magazines could be regulated however the state wanted. So here what's likely going to happen, what seems like it's going to happen, is that this Morse and Anderson case, in front of this judge, are probably going to follow in some way behind the PICA cases. We're going to have to wait and see what the Supreme Court does with all these Illinois cert petitions, if they're going to grant review, deny review, and then ultimately how this is going to play out. The PICA cases, how those are going to play out in front of Judge McGlynn. I would anticipate that the Morrison Anderson suppressor cases are going to sit for a little bit, trail behind those other Pika cases. And once the Pika rifle magazine ban cases are decided, well, then you'll see a ton of movement on the suppressor lawsuits. So as we get more information, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in the Cyber 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.